Counsel for the Respondent.
May it please the court. I'm honored to represent the state of Alabama in this case. The question before the court is whether law enforcement's use of a publicly available ancestry database to identify a criminal suspect violates the Fourth Amendment's protections against unreasonable searches and seizures. The answer, based on established legal precedent, constitutional interpretation, and common sense, is unequivocally no. Today, I will prove 3 critical points. First, the Fourth Amendment does not protect information voluntarily shared with third parties, as reinforced through decades of precedent. Second, the specific nature of 23andMe's privacy policy and its users' consent to data sharing invalidates any reasonable expectation of privacy. And third, ruling in favor of the petitioner would set a dangerous precedent that cripples law enforcement and their ability to solve crimes in this evolving digital age. So, the first question, does the Fourth Amendment prohibit law enforcement from searching a public DNA database without a specific warrant? Let's see what the Fourth Amendment says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The key phrase here is unreasonable searches and seizures. The Supreme Court has long held that a search is only unreasonable when it violates a reasonable expectation of privacy, as seen in Katz v. United States. The question before this court is whether Gambini had a reasonable expectation of privacy in the DNA that led to his arrest. Now, this court has consistently ruled that when individuals voluntarily provide information to third parties, they relinquish their reasonable expectation of privacy in that information. This principle, known as the third-party doctrine, has a lot of precedence. Now, in United States v. Miller, the bank ruled that records are not protected under the Fourth Amendment because individuals voluntarily provide them to financial institutions. In Smith v. Maryland in 1979, the court held that a suspect had no reasonable expectation of privacy in phone records because, again, this was collected by a third-party telephone company. In Katz v. U.S., this precedent of Katz v. U.S. does not apply because the circumstances are too different. In Katz v. U.S., there was constant surveillance. Here, there is no constant surveillance being done. Now, Maryland v. King in 2013 stated that warrantless DNA collection is constitutional, as it is like taking in the full layout of a crime scene. If we take this in conjunction with Katz v. U.S., we can see that taking these fingerprints off the car were just a part of the officer's duty in making this, in determining potential suspects. The police's interest in identifying who they arrested outweighs the individual's need for privacy. In Riley v. California, the court ruled that a warrant is needed for digital data. Now, the police did obtain a warrant legally and legally acquired the data afterwards, so there's nothing that's going wrong there. And of course, Carpenter v. U.S. is an interesting case. The cell location obtained by law enforcement without a warrant is what is talked about here. Now, unlike Carpenter, Gambini voluntarily provided his data. It wasn't collected automatically. And unlike CSLI, DNA data does not provide continuous real-time surveillance and movements. Now, the court in Carpenter also explicitly limited its ruling to CSLI and did not extend it to all third-party records. Now, if bank records, phone logs, and even garbage are not entitled to the Fourth Amendment protections, then DNA uploaded to a publicly accessible database like 23andMe certainly is not protected. Now, let's turn to 23andMe's own privacy policy. Now, the terms of service make it clear that users voluntarily submit their DNA for analysis and storage, and the company retains the right to disclose genetic information in response to legal requests. So the exact wording says, since 2008, your individual data has never been released to law enforcement and will only be shared if required by valid legal process. This is a valid legal process. There was a warrant obtained by the court to search this database. Now, given these terms, there's no reasonable expectation of privacy submitted to this 23andMe DNA database. Gambini's claim was that an illegal search ignores this well-established legal principle that people are bound by the agreements that they make. These terms of service that no one actually reads contain a lot of pertinent and important information that a customer must take in before deciding to give their information to a company. Now, the petitioner will argue that this search was unconstitutional because it involved an unspecified warrant and potentially exposed the genetic information of innocent individuals. Let us dissect these claims. Now, this warrant argument is an interesting one. It's a red herring. The law enforcement did not physically seize Gambini's DNA from Gambini's person or home. They got it off of an abandoned car. And they examined a publicly available database, which contained data voluntarily shared by users. Now, if Gambini's argument is correct, the police would need a warrant to search Facebook, Google, and public tax record, which is quite frankly absurd and prolongs legal processes. Innocent people are impacted argument is also very misleading. The law enforcement routinely searches large data sets, phone records, bank logs, and security camera footage to find a suspect. The existence of innocent individuals in a data set does not make the entire search unconstitutional. A license plate check that examines thousands of plates in a year to find a suspect is, by this logic, unconstitutional. Yet no one claims that this violates the rights of innocent drivers. And then, number 3, digital databases do not create a special class of privacy rights. Gambini's argument implies that DNA databases deserve more protection than other third-party records, and the court rejected this logic in Carpenter v. US. Now, if the court finds in favor of the petitioner, it would artificially create a new privacy right that does not exist in law and hamper investigations for future investigations for law enforcement. Now, why should you rule in favor of Alabama? In the digital age, law enforcement must adapt to new tools that are at their disposal to keep our communities safe. They must do everything they can to keep criminals off the streets. The Fourth Amendment does not exist to shield criminals from being identified through legitimate publicly available records. Again, I'm restating time and time again, let there be no question that this was, 1, a legal process, completely legal. There was a judge that gave a warrant, and 2, this is a publicly available database. The court must uphold the decades of aforementioned legal precedent confirming that third-party data is not protected by the Fourth Amendment and the third-party doctrine. The users of 23andMe voluntarily uploaded their data, waiving any reasonable expectation of privacy. Everyone who clicks the I agree to the terms and services and doesn't read them is missing out on this one key fact, which is what I think the petitioner is surely misinformed about. If the court rules in favor of Gambini, it will undermine law enforcement's ability to investigate crimes and protect communities. But a ruling for Alabama will affirm that public databases remain a valid and lawful tool in the fight against crime. For these reasons, I urge the court to uphold the Alabama Supreme Court's ruling and affirm that evidence obtained from 23andMe is admissible under the Fourth Amendment. In their arguments, the petitioners have failed to respond to many of the justices' questions. Now, Justice Jackson had asked, if Jackson went to a hair salon and the police wanted to search a hair bag, would that be unconstitutional? No, it wouldn't, because again, it's very, very similar. They're looking for one specific person's, one specific person match. And after they do that, they discard any of the irrelevant DNA or evidence that they obtain. So the fact that the petitioners are not able to answer these very, very similar hypothetical scenarios really does lead you to believe that the petitioner has no basis for their arguments that they're making here. And that the way of the respondent and letting the police officers upholding this data that was collected validly and lawfully is the right way to go about this case. Thank you.
Thank you, counsel. With that, we'll move into justice questioning. I believe we left off